Prince Harry needs to tell himself enough now.
Prince Harry just left the United Kingdom, and what happened next is being called, by people close to the proceedings, a diabolical disaster. But here is what most coverage is getting completely wrong. This is not simply a story about a courtroom loss. It is a story about a decision that was already undermined before Harry ever boarded that plane.
His UK trip was a diabolical disaster. He leaves Britain broke and with egg on his face.
The key players are Harry, his legal team, and a judge whose ruling was anything but sympathetic. What started this? A case Harry believed he could win. He could not. And the real question is, how much did it actually cost him? The ruling dropped on a Tuesday, and it was not close. Judge Matthew Nicklin, presiding over the UK High Court, dismissed every single claim brought by Prince Harry and his 6 co-claimants against Associated Newspapers Limited, the publisher of the Daily Mail. Not some claims, and sources close to the proceedings say the judge's reasoning was precise, deliberate, and almost impossible to appeal on grounds of legal error. Here is what Harry had to prove. The legal bar required him to demonstrate, with actual evidence, that specific information used in specific articles had been obtained through unlawful means. That is the standard. That is what the courtroom demanded. Now, Harry's legal team argued something that, on the surface, sounds reasonable. They said that because the information was private, and because A&L could not fully explain where it came from, the court should conclude it must have been unlawfully sourced. Judge Nicklin rejected that argument completely. His ruling stated, in precise terms, that suspicion, however reasonable, however well-founded it might feel, is not proof. The claimants had to prove unlawful gathering. They did not. And here is where the history matters. This case did not emerge from nowhere. Harry has been engaged in a multi-front legal campaign against British tabloid publishers for years, winning some battles, settling others, and genuinely reshaping parts of UK media law along the way. That track record quietly created an expectation, inside his circle and in public, that this case was winnable. Harry's team believed the sheer scale of discovery, the volume of documents, the length of a 45-day trial would surface the kind of direct evidence that would clear the bar. It did not surface the mechanism they needed. A document, a communication, a digital trail that tied A&L journalists directly to unlawful sourcing. It never materialized in the form the court required. A&L, for its part, simply held its position. It did not need to prove innocence. It only needed the claimants to fail to prove guilt, and they did. So the verdict stands. Every claim dismissed. Harry leaves the courtroom, legally speaking, empty-handed. But what this ruling actually cost him, in pounds, in reputation, in leverage, that is an entirely different calculation. And the numbers, when you see them laid out, are genuinely staggering. And that is where the story gets genuinely brutal. Because winning or losing the legal argument is one thing, but the bill that comes with losing it, that is something else entirely. Legal expert Andrew Fremlin-Key, a partner at Withers specializing in media and information disputes, gave the clearest assessment since the verdict landed. His words were precise and deliberately measured. He said that although A&L succeeded, financially there is no real winner in this trial. With reported legal costs of around 40 to 50 million, this has been, in his words, a very expensive privacy case. No real winner, at 40 to 50 million combined. The court had actually tried to contain this. Back in December 2025, High Court judges David Cook and Mr. Justice Nicklin flagged the estimated 38.8 million cost as clearly outside reasonable. They expressed concern about the personal financial risk to Harry and the other claimants if they lost. The court-imposed ceiling for the final trial phase set the claimants at approximately 4.1 million and A&L at approximately 4.5 million. That sounds like a lie, and it was, on one phase of a case that had already been running for years with costs stacking long before the trial doors opened. This was not Harry's only bill. Earlier in the same legal period, a judge ordered him to pay nearly $50,000 following a separate A&L libel matter. That figure barely registers now against what sources suggest the full picture looks like. So what is Harry's actual share going forward? Nobody is giving a clean answer. What is clear, costs in cases like this typically fall on the losing party, and Harry's side lost. Every claim dismissed. The exposure is not theoretical, it is structural. The pre-trial spending ambitions told their own story. A&L had sought authority to spend the equivalent of $24.7 million for the 45-day trial alone. The claimants were targeting $23.4 million on their side. Those are not legal fees. Those are small fortunes committed to a case that returned nothing. And here is what Fremlin Key's no real winner framing quietly implies. A&L spent heavily to defend. Harry spent heavily to attack. The court imposed lies that still ran into millions. The result is a draw that feels, financially, like a loss for everyone, but lands hardest on the side that brought the case and walked away empty-handed. The money is one wound, but the timing of this verdict cut differently. Because Harry was not sitting quietly somewhere when the ruling dropped. He was in the UK, in public, on a stage. And the week surrounding that moment had already been unraveling in ways that made everything worse before a single word of the judgment was read aloud. And here is the thing about timing. It was already broken before the verdict existed. The week Harry arrived in the UK for his Invictus Games obligations had been chaotic in ways that sources say were entirely avoidable. The family question, whether anyone from the royal family would see him, acknowledge him in any meaningful way, had been flickering on and off for days. Sources suggest there were signals, quiet ones, that some form of contact might happen, then counter-signals, then silence. The flip happened more than once. But the accommodation issue is what made it genuinely damaging. Sources say Harry was offered a room at a royal residence. Not a grand gesture, just a practical arrangement, a place to stay during the visit. He accepted. Then, according to sources familiar with the sequence, the offer was withdrawn. Harry was left to make other arrangements, which he did, and which immediately became a story of its own. Individually, none of these things are catastrophic. A housing logistics issue. A visit where family meetings didn't materialize. These are frictions that happen in complicated families all the time. But sources close to observers of the palace say that collectively, the pattern told a specific story. One of a man who had flown across the Atlantic for a legal outcome that was simultaneously unraveling, surrounded by family signals that kept shifting under him. That is the backdrop the media already had when the ruling dropped. He looked out of step before a single word of the judgment was read. Disorganized. Caught between two worlds with full standing in neither. The image was already forming. So what happened when the verdict actually broke? Harry wasn't somewhere private. He was on a stage, at a microphone, in front of an audience. And the timing of that, the precise, brutal timing, is what turned a bad week into something else entirely. And here is the part nobody fully registered in the moment, because the moment itself was so chaotic, it swallowed its own details. When Judge Nicklin's ruling broke publicly, Harry was not sitting quietly somewhere with lawyers. He was standing at a podium inside Chatham House in central London, delivering remarks at an Invictus Games advocacy event. The timing was not engineered by anyone. It did not need to be. The coincidence alone was devastating enough, because what the media had, in real time, was a split screen that wrote itself. On one side, a prince speaking about resilience, purpose, and the dignity of wounded veterans. On the other, a judge's ruling quietly confirming that his 7-year legal pursuit had produced nothing. No findings of unlawful conduct, no vindication, just a bill and a closed door. The Invictus Games is genuinely the one thing about Harry's post-royal life that nobody has ever seriously attacked. It works. Veterans say it works. The message is real. Sources say Harry understands on some level that it is the strongest card he still holds. He chose it deliberately as the visible centerpiece of this UK visit, the thing that would remind people what he was actually fighting for beyond courtrooms. That choice completely backfired, not because of anything he said on that stage, but because the news cycle does not pause for sincerity. Every outlet running the verdict also ran the footage of him at that microphone, which transformed his most credible platform into background scenery for a collapse. The message was erased. What remained was the image. Sources suggest this is the moment the week became something permanent, rather than just a bad few days. The timing did not just hurt his legal case, it contaminated the one cause that had been protected from the rest of the noise. So how did Harry reach a place where even his strongest ground could be taken so completely? The answer requires going back, much further back than this week. It starts around 2018, when Harry and Meghan were still inside the institution, attending engagements and playing the game. Sources suggest that behind that public surface, Harry had already begun consulting legal teams about what he believed was a coordinated campaign of unlawful intrusion by British tabloids. The decision to pursue it formally came shortly after the couple left for North America in early 2020. What followed was not one lawsuit, it was 3 simultaneous legal campaigns against News Group newspapers, Mirror Group newspapers, and Associated Newspapers Limited, pursued across years, across courts, and at costs that sources now describe as staggering even by royal standards. And the record was genuinely mixed, which is what makes this final loss so significant. Harry settled with Mirror Group. He won a partial victory there in 2023, which gave him genuine momentum and the belief that the A&L case was winnable on the same logic. He settled against News Group, the publisher of The Sun, in January 2025, a settlement that came with a public apology that Harry called historic. Those two outcomes were what kept him going. Each settlement felt like validation. Each victory felt like proof that the pattern he had always described was real and provable. But the A&L case was different. The legal bar, as Judge Nicklin said it, required more than establishing that private information had been published. It required proving the information had been obtained unlawfully. Suspicion, even well-documented suspicion, was not enough. Now, 7 years in, the balance sheet reads like this. 2 partial wins, 1 total loss, an estimated $40 to $50 million in combined legal costs across the full campaign, a security battle against the Home Office still unresolved, and a monarchy challenge that sources say consumed enormous political capital without producing lasting change. Nothing individually would have broken him, but collectively, across 7 years, the accumulation is what sources describe as genuinely unsustainable, financially, reputationally, and strategically. The question now isn't whether Harry can afford another round in court. It's whether he can afford what this war has already done to the one thing legal victories were supposed to protect: his reputation, and that damage runs deeper than most people have acknowledged yet. So, the legal losses are only part of what's been destroyed here. Because the more serious damage, the kind that doesn't show up in court costs, is reputational. And that argument has been made most sharply by commentator Angela Mollard, who framed it in terms that are genuinely difficult to dismiss. Harry's entire public project, the reason he gave for leaving the institution, for the memoirs, the interviews, the legal campaigns, all of it was built around a single proposition: that he wanted to be known for compassion, for mental health advocacy, for the men and women who serve under the Invictus banner. That was the identity he was constructing outside the palace walls. But sources say what the last 7 years have actually produced is the opposite of that identity. The man who wanted to be defined by healing is now defined by conflict. The causes he genuinely champions, and the evidence suggests he does champion them genuinely, are being buried, not by his enemies, by the noise of his own legal war. And here is what makes that so difficult to reverse. Every courtroom appearance, ruling, leaked cost estimate, headline about settlements and appeals pulls the public narrative away from Invictus and mental health and back toward the same story: Harry versus the press, palace, and everyone. Mollard's argument is not that Harry was wrong to fight. It is that fighting this long, this publicly, this expensively, has quietly dismantled the very reputation the fight was supposed to protect. And that mechanism, sources suggest, was not an accident. The opposition stumbled into. It was the predictable outcome of a campaign design that prioritized legal vindication over public perception. The vindication never fully came, but the perception damage, that arrived on schedule, which raises the question that now sits at the center of everything. Does Harry try to appeal? And if he does, what does that actually cost him? The answer is not as straightforward as it sounds. Because here is what the July 29 hearing actually represents. It is not an appeal. It is a procedural session, 2 days long, designed to resolve outstanding disputes about the judgment's terms and any required court orders before anything else can move. That hearing has to happen first. Only after that does the question of an appeal permission request even become live. And this matters, because there is no automatic right to appeal. Harry cannot simply file in advance. The Court of Appeal has to grant permission, and sources familiar with the process are clear that it will not rerun the trial, will not look at evidence afresh, weigh witnesses again, or revisit factual findings that Judge Nicklin already made. It will only consider whether there was a genuine legal error in how the law was applied. That is a significantly narrower door than Harry's team would need to walk through. Now consider what walking through that door would cost him. Financially, his legal exposure is already staggering. An appeal round extends it further, with no cost ceiling guaranteeing protection on the other side. Sources suggest the combined costs already embedded in this case have run deep enough that adding a permission fight and then a full appeal if granted risks compounding losses on a figure that already has no winner attached to it. But the reputational cost is arguably worse. Every month an appeal runs is another month. The story remains: Harry versus the press. Another month, his own narrative platform sits underneath a legal headline he cannot control. He is not appealing from a position of strength. He is appealing, if he does, from a corner. Which makes what comes next the only question that actually matters. Can he still find a way back? So here is the only question left. Can Harry actually come back from this? The people around him have been asking that privately for months. Not whether he should pivot, everyone agrees he should, but whether the pivot is still available to him, whether the door is still open, or whether 7 years of public warfare has quietly sealed it from the inside. Because the path Harry originally mapped for himself was genuinely compelling. Invictus, mental health advocacy, military service reframed for a modern era. Those causes were real, and for a window of time, they worked. The early Invictus Games generated the kind of coverage that made the palace nervous because it was completely uncomplicated. No courtrooms, no tabloids, just Harry, veterans, and a cause that was difficult to argue with. That version of him still exists somewhere in the record, but sources suggest it has been buried so thoroughly beneath the legal machinery that most people under 40 couldn't tell you the last time Harry made news for something that wasn't a lawsuit, a memoir excerpt, or a family falling out. And that is the actual damage, not the verdict, not the costs. The damage is the deliberate replacement of one identity with another, and the growing uncertainty about whether the original one can be recovered. People do come back from worse. There is no permanent ceiling on rehabilitation in public life, and sources close to people who have navigated similar situations suggest the formula is always the same. Stop talking, do the work, let time pass, let outcomes speak. Harry knows this formula. He has advisors who know it better, but the formula requires him to stop. And stopping means accepting that the legal avenue is closed, that the public verdict has already been delivered, and that continuing to fight is now costing him the very identity he says he is trying to protect. He has not shown, so far, any clear signal that he is ready to make that acceptance, which is what makes this genuinely unresolved. Not whether Harry can rebuild, he probably can if the conditions are right, but whether he will choose to create those conditions, or whether he will push for an appeal, extend the timeline, and hand the press another 18 months of Harry versus everyone headlines he cannot control. Sources say people close to him are waiting to see which Harry shows up in July. So is everyone else, and the answer will determine whether this chapter is the ending, or just the point from which everything gets harder. Harry lost. The Daily Mail walked. And with 40 to 50 million in legal costs and no guaranteed appeal path, the bigger question isn't what this cost him financially, it's what leverage he has left. Call it what it was, checkmate.